and welcome to Law and Sarasota. I'm your host, Adam Tabrouge. And as we begin our 7th year of producing this program, I'd like to give a special thanks to the Education Channel and to the Sarasota County Bar Association and to the Community Foundation of Sarasota for making this show possible. Today, I'm joined by one of the top attorneys in Sarasota, Carol Ann Kalish. Carol Ann, welcome to the program.
Thank you so much for inviting me. I'm happy to be here.
Carol Ann, you and I are going to talk about the Patient Protection and Affordable Care Act. But before we do, why don't you tell our audience a little bit about yourself and how you became an attorney?
Sure. I think like a lot of people, law wasn't my first choice. I think also like a lot of lawyers, I'm the child of a lawyer. My dad was a lawyer, a litigator. When I went to college, I thought I wanted to be a psychologist. I was a big reader and a big talker, and I liked to solve problems. And that seemed like a great career, but it turned out that there wasn't a lot of problem solving, just a lot of advice giving in the psychology field. And so I guess reverted to form, and after a very brief stint in the retail world, which was fun, but not particularly remunerative, I decided to go to law school, and I haven't had a day of regret since.
Carol Ann, where did you go to law school and how did you find that experience?
I went right down the road to Stetson. I was newly married at the time, and I commuted every day from Sarasota across the gorgeous Sunshine Skyway to get my head on straight. I loved the experience. I treated it, I think, as a non-traditional student. I had a little different perspective on it. I was about 5 years older than some of my classmates. So I treated it like a job. I got to school at 7 in the morning and didn't leave before 7, and enjoyed all of the intellectual stimulation, all the reading, loved it, participated on the moot court teams, so that was great too. It was a wonderful experience. Clerked at Williams-Parker, got my job, and have been practicing for almost 20 years.
Tell us a little bit about Williams-Parker and the services offered by that law firm.
Williams-Parker is almost 90 years old. It's really been a part of the fabric of Sarasota since 1925. We're a multi-service firm, and I think that the way our practice has grown really reflects what the business and professional interests in Sarasota are. I, along with several of my colleagues, practice health law because we have a large, incredible public health care system in our town that needs and gets great work and attracts a lot of folks to town. We do business and tax planning, do a lot of real estate work, including land planning, and trust and estates work. So we're kind of reflective of the community.
And Carol Ann, that's why I wanted to have you on the program today. Certainly there's been some significant changes in healthcare law in recent years. And going forward, I want our audience to understand what some of those changes mean for them. And specifically, we're going to be discussing the Affordable Care and Patient Protection Act, which is sometimes known in the media as Obamacare. The law has been upheld by the United States Supreme Court. So my first question to you is, could you discuss some of the benefits for patients that are outlined in that act?
Sure. I think it's important to talk, when we talk about that, to remember what the goals of the act are. And regardless of your political affiliation, I think everyone can appreciate that healthcare is a really important part of most Americans' lives. If it hasn't been already, it will be. And the goal of the legislation was to get more people covered by insurance, improve access to care, and improve outcomes so that overall as a population we could be healthier. The way that the act does that has caused some controversy, but what it ended up doing is attempt to make sure that more folks are covered by insurance. So for an individual consumer, the United States, probably because of the way health insurance developed in our country, the United States primarily delivers health care as an employee benefit, insurance as an employee benefit. So still now, 65% of the folks who have insurance get it through their employer. That's probably not going to change very much. It seems like a lot of people have talked about it, but it's probably not going to change. For individuals who are uninsured or underinsured, the law sets out a lot of different pathways to gain insurance by setting up insurance exchanges that are going to provide information to consumers about where they might find affordable insurance, by setting up supported plans so that you can get subsidies for paying for your premiums for health care. And by the sort of continued controversy is by potentially expanding eligibility for federal and state funded insurance through the Medicaid programs. In talking about the PPACA being upheld by the Supreme Court, that was the one area that the Supreme Court said could remain as a voluntary provision, that the states could opt in or opt out. As most folks know, Florida now has indicated an intention to possibly opt in. So that's another area for folks who had been uninsured to gain insurance. So now if the goal is to get more people insured, and we do that by those particular provisions, then the law also has provisions that attempt to make your access to health care more effective. So there is encouragement in the law for healthcare providers to work together to provide a better healthcare experience for individuals who have insurance. So many individuals will be seeing from their physicians encouragement toward better management of their wellness. We've always been a society that has done a really good job of taking care of sick people because that's the way our insurance has always kind of worked, but maybe not the best job of keeping people well. So there are incentives built into the law for consumers to take a more active role in maintaining their own health, to incentivize their physicians to keep them well. And so for individuals who are uninsured, they might have better access to insurance. For individuals who are already insured, probably the biggest change is going to be a continued progression toward the idea that insurance plays a role in wellness, not just in illness.
You know, Carol Ann, even though I'm an attorney, I have a difficult time understanding insurance issues. Could you discuss with us a little bit more these insurance exchanges and some of the assistance that might be available to consumers like myself?
Sure. I can a little bit, but some of it is still a little unsettled. Unfortunately, because of the uncertainty around the law, there hasn't been as robust a movement. You know, the law was passed almost 3 years ago. But it really has just started to take hold recently. But what is supposed to happen? Let's first start talking about the insurance exchanges. There is going to be a center of information that will be government administered that is going to have all of the information that a consumer might need in making decisions about healthcare. So if a consumer goes to a website, and some of those websites are out there now, if you go to that website, you input your information, it's very individualized, all of the folks that you need to get covered under insurance, and it'll provide all of the options for you with cost estimates on what the premium expense might be, what your level of coverage might be, and that's all going to be automated. And so it really is designed to create a consumer experience much like you might have if you were shopping for a car. Let's face it, a lot of people spend more time shopping for a large consumer purchase than they do for healthcare, even though the implications are certainly more significant with healthcare. This is designed to centralize that information, to make it easier for you to guide you through a questionnaire so that as a consumer, you understand what questions you should be answering. Am I a relatively healthy person? Do I have a sufficient savings that I should get a high deductible plan? Do I have an income level that might provide me with what we are also talking about, which is this premium support? So based on your income level, and it's calculated around that floating federal poverty level, you'll be eligible for support for the premiums you have to pay for health care, because very often anyone who's gone through COBRA understands that when you don't have employer support for your health care premiums, they can be staggering. Particularly if you're well, it feels like money that you're throwing out the window. And the idea is that if we can provide that support, if the government can provide that support, then more consumers will take advantage of these plans. They'll sign up. And so the healthcare exchanges, the information exchanges, will enable folks to understand what their out-of-pocket expense might be for healthcare.
Well, Carol Ann, what about the person who might not have had insurance for some period of time and who suffers from what I'll call a pre-existing condition. Are there provisions in the law for such a person?
There are. Previously, there was a huge burden for folks, both folks who had insurance and folks who didn't, because if you had a pre-existing condition, it very often prevented you from having any kind of economic or geographic mobility. You couldn't really necessarily leave your job if you weren't going to be eligible for later insurance. You couldn't move somewhere or have a period of hiatus where you weren't covered. If you didn't have insurance, it very often created an economic barrier to getting insurance because your premiums would be so high. In 2014, all of that's going to go away. There's not going to any longer be an ability to take into account someone's pre-existing condition when making insurance determinations. Another significant benefit of the law for an individual consumer is that there are not going to be lifetime limits on benefits. So again, very often that would create a real a mobility barrier for folks because they would be on a plan, they would have that plan in place, and they would need that insurance in order to continue to survive. And so this will do away with some of those plan provisions that used to create limits. That's one of the provisions of PPACA.
And Carol Ann, what about cancellation of policies by the insurance company? Or what if I'm not satisfied that the insurance company has been treating me fairly? Are there any aspects of the law that deal with that?
One of the important provisions of the law that provides consumer protection is a prohibition on post-coverage cancellation. Many of us have had friends who have come upon health hard times, filed a claim, only to find that although they had filled out an application, got insurance, been treated as if they had insurance, and paid insurance premiums, have a post-claim cancellation because of allegations that they provided misleading information so that the underwriting wasn't accurate for their insurance. The new law has very strict limitations on the ability of an insurance company to do that post-claim review. A person really has to have intended to commit fraud in order for their policy to be voided. And that's not what we were seeing in the past. So again, that's another very significant limitation. There are also better guidelines with regard to what the appeals process can be for a claim. So if you have an insurance company who you believe has wrongfully denied your claim, all insurance policies have had those claim appeal procedures, but now there has to be an outside review of those appeals. So again, additional consumer protection for those once they get insurance or have insurance.
And I don't know if you're able to comment this or not, but where do agents fit into this picture when we have this law coming into place and the possibility of exchanges and these other limitations and benefits that we've talked about?
I think for insurance agents, there's a heightened responsibility. I don't know if you have a friend who's your insurance agent. I know I do. I consider my insurance agent my partner in doing these things. There is a heightened sense of responsibility on the part of an agent. Certainly, they'll have an important role to play in helping folks get insurance, in counseling both individuals and employers on what their obligations are. Particularly, and we haven't really talked about what this means for employers, but I'm sure we will, but particularly for employers who have existing policies, in guiding them through the grandfathering provisions and in guiding them in what changes they can or should make with regard to their policies.
Well, Carol Ann, your information has been very helpful, and when we return, we'll discuss the role of the employers, and so please stay with us for more Law and Sarasota. Welcome back to Law and Sarasota. I'm your host, Adam Tabrouge, and today I'm with Carol Ann Kalish, and we're discussing the Affordable Care and Patient Protection Act and its impact upon the local community. Carol Ann, when we went to break, we had just begun to discuss some of the impact of this law upon employers in the area. If you could sum up some of those impacts for our audience.
Sure. PPACA, or the Patient Protection and Affordable Care Act, is designed, again, to encourage enhanced coverage, to cover more Americans with insurance. With the recognition that so much of our insurance comes through our employers as an employee benefit, there are substantial provisions in the law that both incentivize employers to either continue to or undertake to provide insurance, but also designed to penalize employers from making a switch away from or deciding not to provide coverage. On the incentive side, there are significant tax credits that are available to employers of a certain size and with employees in certain economic ranges that will give them tax credits for the premium support that they provide for their employees. That's designed both to encourage employers to continue to provide the insurance that they've been providing. You'll recall that a big feature of getting public support for this was telling folks, if you have an insurance plan that you like, we're not going to take that away from you. And certainly that's what this is designed to help effectuate. There are also provisions that would allow employers who have existing plans but are hoping to avoid any of the impacts of the Affordable Care Act to maintain those plans without making a lot of changes and be grandfathered away from or protected from the provisions of the Act, most of the provisions of the Act. There are some provisions of the Act that the Affordable Care Act requires employers to take on in order to maintain a grandfathered status. Those are the removal of lifetime limits on benefits, and one that I forgot to mention in our last segment, which was increased eligibility for dependents up to 26 years of age. So in order to maintain the plan that you want, there is a trade-off there, which is to ask employers to add those coverages so that they can maintain their existing plans. There are also disincentives. So for employers of certain sizes with a certain number of employees, they will have to, just like individuals, employers will have to pay a penalty in order to not provide health care, because the feeling is that because this is so much a part of the fabric of having this as an employee benefit, that if employers opt out, what it means is that other employers are picking up the tab, that their employees are picking up the tab. And so employers are asked to contribute through a penalty based on the number of employees they have and their choice not to cover. Again, these are really complicated provisions. It's funny because reviewing here today, I looked through what I consider to be a very good summary of this law, which is put out by the Kaiser Family Foundation. And the summary in bindsy type was 14 pages, which was pretty good because 14 pages isn't that much. But a lot of the employer provisions require some pretty sophisticated algorithmic thinking. So for employers who want to maintain their plans, they are probably already doing that because a lot of these employer-based grandfathering provisions started back in 2010. For folks who are considering taking advantage of the tax credits that they would get or implementing a different kind of plan or changing their plan substantially, for example, to change from a traditional plan to a high deductible plan with a savings option, there's a lot of traps for the unwary. And so this is when your trusted insurance advisor or lawyer might come in handy for employers.
And I was going to ask you, as an attorney who practices in this field, are yourself and your law firm getting these type of questions from employers? And if so, what kind of information should they assemble prior to meeting with you and asking their questions?
You know, we have a large healthcare practice, and we have a benefits practice as well. So I'll address those two things separately. For an employer who's trying to figure out what they should do or what they want to do, looking for guidance and helping to affect what they want their plan to be, they need to understand what their workforce looks like, how many full-time employees they have, how many part-time employees they have, what their definition of that is, because it might be a little different than what the federal definition is, and to really get a good idea of what they want their budget to look like. For healthcare providers who are wending their way through this, because there are impacts on healthcare providers as well. They may be considering whether to join an accountable care organization, or whether, determining whether or not they can expect increased or decreased reimbursement. For primary care providers, they might be looking at increased reimbursement related to PPACA. For other kinds of providers, potentially decreased reimbursement, depending on what actions they undertake to comply with the law's goals of providing better and more efficient care. It's important to understand, again, what they want their practice to look like in the future and what kind of collaborative measures they're willing to undertake to work with other healthcare providers to have a focus on that whole patient kind of health home concept that is so robustly supported in the law.
Carol-Ann, we had briefly also mentioned the impact of this law upon Medicare and Medicaid. I, for one, sometimes have a little difficulty keeping those two terms straight.
I know.
But could you address some of the impacts upon Medicare and Medicaid?
Sure. Medicare, as most of us know, is the government-supported plan that, by the federal government, that ensures everyone over the age of, or eligible for insurance over the age of 64 and a half, and some folks with qualifying disabilities. So that's the closest we get to a single payer in the United States. In this area, it's pretty impactful because we have a lot of seniors who live in our area. The funding for this enhanced insurance throughout the rest of the demographic comes in large measure from changes to Medicare reimbursement. The expectation is that the same hospitals that are caring for a lot of seniors now and are disproportionately caring for Medicaid folks or folks who are uninsured, they get a payment through their Medicare reimbursement for that. Those payments, they're called disproportionate share or DISH payments, are going to be reduced in order to fund that insurance. That's going to have a really high impact in areas with a high Medicare population because the expectation is that changing demographic, that spreading of the insurance, isn't really going to make up for the entire amount of the DISH. So that's going to be a big impact. Medicaid, which we touched on a little bit earlier, is the program that provides insurance coverage for younger folk, children, non-working moms, the poor, in some cases the working poor. That is a state-federal collaboration. And so those rules right now, you have a certain percentage of the population who is covered, and it's mostly children and non-working moms with children. The expectation is that eligibility will expand. And so the federal government has agreed that states who expand their Medicaid eligibility, that the federal government will provide funding for 100% of that expansion for 3 years. And so there are going to be a lot of folks who are going to have to take a hard look at whether or not they're within, it's 133% of the federal poverty limit, and determine whether or not it makes sense for them to apply for Medicaid and get that coverage in the hope that you have this wellness management so you keep people healthier, keep people out of emergency rooms. That's all affected by PPACA.
Well, Carol-Ann, now that the bulk of the law has been upheld by the Supreme Court, using your crystal ball and looking into the future, what type of impacts might us local consumers expect to see over the next year or so?
I think that over the next year or so,
or farther.
Or 5 years maybe, I think what you're probably going to see, potentially, is an increase in the number of primary care providers moving to this area. So for folks who are looking for a doctor, you might have a greater capacity to find one. You might also see your primary care doctor who encourages you to see their their provider support. So if your physician has a physician's assistant or an ARNP that they work with, for some routine office visits, you might be encouraged to go to them, because with an increased insured population, all doctors are going to be busier, and if the new doctors haven't moved in yet, you're probably going to see that. For consumers who are looking for insurance, they're going to have a lot of changes. They're going to have, for the working poor, they might have greater accessibility to being Medicaid eligible or access to low-cost insurance. You may see some employers who change their policies in order to take advantage of some of the incentives that are given, and so you might see minor changes for those who are already insured in the way that your health plan is run. I think everyone who's insured is going to see an enhanced and continued push toward consumers taking control of their health and working toward maintaining wellness as opposed to episodic care of illness. I think that's kind of becoming more and more fixed in our national consciousness, and PPACA solidifies that a lot. And so I think that for all of us, there's going to be a push to wellness, which of course is a good thing.
Carol Ann, I know that there's a lot of people at your law firm, Williams Parker, who are working hard in the healthcare area. If members of our audience have additional questions that would be appropriate to direct to the folks at Williams Parker, how might they get in touch with you?
Oh, we love to help. We have a website, which is www.williamsparker.com, or they could just call and ask for me. Our number is 941-366-4800.
Well, Carol Ann, you've truly provided a wealth of information to our viewing audience today, and I really appreciate your willingness to come on the program and discuss these many changes in healthcare that our community will be seeing over the next few years.
It was my pleasure. Thanks so much.
And I'd like to thank you for watching another episode of Law and Sarasota.